This is Colin O'Keefe for LXBN TV. Lost in the shuffle of the high-profile same-sex marriage decisions last week, the Supreme Court handed down a major victory for landowners in Koontz v. St. John's River Water Management District. Joining me now to explain the ruling and its impact nationally is Nossaman attorney Brad Kuhn. He is author on their blog, the California Eminent Domain Report. Brad, first, can you, as best you can, explain this ruling in plain English? What exactly does this mean?
Sure. The court made two significant findings as far as I'm concerned. First, when a property owner seeks to develop property, the government cannot condition the proposed development on the owners paying the government money unless the monetary exaction is proportional and related to the impacts that are going to be caused by the project. So, for example, if the government can't condition the approval of a residential development on the developers contributing $1 million for a new park, unless the government's going to be able to show that the residential development is creating the need for the new park, and also that the payment amount is proportionate to the developer's fair share of the cost of the park. This proportionality and relationship test, it's already been the law as it pertains to real property exactions. So, in that same exact example, substitute out the owners giving money for the park and instead use the government's demanding the owner dedicate property for a park. It would have applied there, but it hasn't applied for monetary exactions. And Koontz changed that. The court found that money essentially is property and that the government's demand for money in return for development approval is the same as the government's demand for land, and therefore the same relationship and proportionality tests must also apply to monetary exactions. The second main finding of the court is that the court held that when the government attempts to impose an unconstitutional condition on the proposed development, the property owner doesn't need to accept the condition in order to challenge it. The government's argument was that if the owner rejects the condition and files a lawsuit, then there hasn't been a relinquishment of real property, and therefore nothing has been taken under the Just Compensation Clause of the Fifth Amendment. The court rejected this argument and held that it would be pointless to require a property owner to pay the money and obtain the permit simply to challenge this unconstitutional condition. If the owner decides to challenge the condition before paying the money and obtaining the permit, the owner may not be entitled to just compensation, but the owner still is entitled to have the improper condition removed.
I see. And second, just how big of an impact does this have across the country? As you mentioned in your blog post, it could be a very big one.
Well, it will be really interesting to see how this decision plays out, especially as the interactions between local government agencies and property developers across the United States. I've seen some suggest that Koontz will have a perverse impact on development, making it difficult to require property owners to pay to mitigate the environmental damage that's caused by their projects, or that it may force local governments to simply deny development permits all across the place because they're fearing that they're going to be sued if they try to negotiate a compromise on some of the required conditions. I don't necessarily agree with some of these pessimistic views, but I'm from California, and states such as California and Texas, for example, they've already generally required that most monetary exactions meet these proportionality and nexus tests. And I'd say that these states seem to be getting along just fine with new developments. If anything, I think these proportionality and relationship tests, they usually force local governments to take a more studied or systematic approach in analyzing proposed developments. And it really makes them think about what impacts are going to be caused by a project and what needs to be accomplished in order to mitigate those impacts. So again, this decision isn't prohibiting money or property exactions. It's simply saying that if the exactions that are levied by the local governments, they need to bear a relationship to the impacts that are being caused by the development. But again, this monetary exaction requirement, it hasn't been the law in many, many states. And so it's going to change the way that local governments interact with property owners.
I see. It'll be interesting to watch because, as you mentioned, this has been the law in states like California and Texas, and it hasn't hindered development too much there. So hopefully that holds true in other states as well. Once again, that was Nossaman attorney Brad Kuhn. For more of his insight on the Koontz decision, be sure to visit California Eminent Domain Report.com, and of course, come visit us at LXBN.com for more of these LXBN TV video interviews. And we also have curated commentary from the Lex Blog Network's more than 8,000 members. And within that, we have a wealth of recent analysis on Supreme Court decisions as well. Thanks for joining me today, Brad.
Thank you.